The Assembly is back in session. Members, please return to the floor. Members, please return to the floor. Mr. Jones, for what purpose?
Thank you, Mr. Speaker. Just to announce vote change, file item 16, AB 141, no to aye.
Jones, Assembly Bill 141, no to aye.
I'd like to ask all members to please come back to the floor. We are back in session, and we are reconvening, and I'm asking the sergeants to bring in the absent members. We will begin momentarily. At this time, we're going to go to Senate third reading. File item 77 is going to go to the inactive file. Moving now to file 78, SB 18. The clerk will read.
Senate Bill 18 by Senator Hill and others, an act relating to the Public Utilities Commission.
Mr. Mullen, you're recognized.
Thank you, Mr. Speaker. Senate Bill 18 requires that the California Public Utilities Commission vote to approve a contract for outside criminal counsel and requires the contract go through a 30-day joint legislative budget committee review. This bill is in response to the PUC spending $5.2 million of ratepayer money on a criminal defense attorney without so much as a vote of the commissioners. Assembly Budget Sub 3 determined that the PUC paid for this attorney out of money that would have otherwise gone toward hiring legislatively authorized positions, improving information technology, strategic planning, and employee training. This straightforward means of oversight in SB 18 would incentivize the PUC to be very clear on the purpose and scope of any proposal to spend utility customer money on criminal defense, and I respectfully ask for your aye vote.
Seeing and hearing no further debate, the clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. The clerk will close the roll, tally the votes. Aye 64, no 0. Measure passes. File item 79 and 80 we will pass and retain. Moving now to file item 81, SB 251. The clerk will read.
Senate Bill 251 by Senator Roth and others, an act relating to disability access.
Assemblymember Stone, you're recognized.
Thank you, Mr. Speaker and members. The Americans with Disabilities Act was passed a number of years ago and has been looked at, and our implementation of it amended a number of times. What we have before you is a highly negotiated bill that tries to put small businesses in the best frame possible to be able to do the work necessary to make their facilities accessible to all Californians. Too often, these bills are chipping away at the rights that all Californians have for actual access to the facilities that we all enjoy. Consider yourself being in a wheelchair. Consider yourself being visually impaired or have some other impairment that you then couldn't come onto this floor easily, leave this building, go to a restaurant, go out with your friends to be able to do the things that we do on a normal basis. All Californians, all Americans have a right to that access. What this bill does is provide more information to small businesses, because the crisis really is a lack of information, a lack of education about what a correctly done facility is to allow access. It also incentivizes the Certified Accessibility Specialist Program, the CASP program, in order to make sure that small businesses, all businesses, are utilizing that program to the best extent possible so that they know where their accessibility access issues are within the business that they're running. This is an important bill. There's another bill that's in the Senate that hopefully will be coming back for concurrence that solves a similar part of the problem of the lawsuits that happen around for small businesses. This bill, though, and both bills together are intended to provide the best incentives that we can to make sure that businesses are compliant with the ADA, that they are open and available for business for all Californians, and that businesses are educated at an appropriate level to come up to speed with the current standard of, or the applicable standard of, access codes and regulations here within California. Again, Senator Roth worked on this very, very hard with the disability community, with the attorneys, the consumer attorneys of California, with the Chamber of Commerce of California, and we've gotten a tremendous amount of agreements. I know that there are still some remaining concerns with it. Senator Roth and I are both committed to continue to work through those issues so that we're no longer chipping away at the rights of the disability community and truly making sure that all California businesses, all California structures are open and available to all Californians. And I respectfully request your aye votes.
Mr. Bonta, you're recognized.
Thank you, Mr. Speaker and members. I rise today to raise concerns about SB 251, which seeks to protect small businesses from being sued for denying access to people with disabilities. This proposed motive certainly makes sense. There are many good reasons why we should protect small businesses, our mom and pop shops, from closing their doors due to expensive lawsuits. It makes sense to give them a little more time than others to remedy the violation so they are not forced to shut their doors. They may not have the resources to comply quickly. They may not have the legal counsel to have known that they were in violation. So I certainly get why lenience could be a prudent approach under these circumstances, but those exceptions must remain limited to small businesses. Otherwise, we are frustrating the purpose of the exception and chipping away at the rights of the disabled. SB 251 extends the current protections for businesses that have 25 or fewer employees to those that have up to 100 employees. This quadruples the size of the businesses protected, covering over 98% of businesses in California at the expense of people with disabilities. Disability rights groups in opposition have come forward with a reasonable solution to this, in my view. They simply ask that the bill apply to businesses with employees of 50 or fewer, not 100 or fewer employees. Ideally, certainly all businesses should have to comply with the ADA in order to give every Californian an equal opportunity to eat and shop and enjoy all the businesses in the state, but we've had to make some concessions and exceptions under extraordinary circumstances. Businesses with 100 employees are not the exception. They are the majority. They are the rule, again, making up 98% of California businesses. So I rise with those concerns, and I respectfully ask that for those to whom that is compelling, that you consider laying off the bill. Thank you.
Ms. Olson, you're recognized.
Thank you, Mr. Speaker and members. I rise in support of SB 251 and appreciate so many of the members as well as the stakeholders who have worked very hard on this issue throughout the entire year. And to be honest, over the last 5 years that I have served in the State Assembly, my appreciation to the Chairman of the Judiciary Committee and others who have truly spent a lot of time working on this issue. The fact is, the Americans with Disabilities Act is a good law. And our goal should be to encourage compliance and increase access for members of the disabled community, because that's the intent of the law. The law was never intended to be abused by greedy plaintiffs and trial lawyers who manipulate members of the disabled community, who take advantage of small business owners, of all business owners, for reasons that have nothing to do with increasing access. That needs to be our goal. And I think that's something that we can all agree, that increasing access for the members of the disabled community in public and private buildings should be the goal. And what's happening today in the state of California, where we have a higher percentage of lawsuits than any other state in the nation, what's happening today in the state of California takes away from that goal, because it ties up hundreds of thousands of dollars in endless, unnecessary litigation, instead of allowing that money to go back into the business where employers can improve access, where employers can better serve their customers, disabled and non-disabled alike. That's the goal. That's what this bill seeks to achieve. It is a very small step in the right direction. It doesn't make a whole lot of sense to me that this would only apply to businesses of 50 or fewer employees, but it's a step in the right direction. It's an important step in the right direction. It's good for small business owners. It's good for members of the disabled community, including people like my own niece. So let's all come together. Please support this bill. It is important to California's long-term economic success and the quality of life for everybody who calls California home. Urge an aye vote on SB 251.
Seeing and hearing no further debate, Mr. Stone, you may close.
Thank you, Mr. Speaker. I am very well aware and sensitive to the issue that was raised here on the floor, and I'll leave it to you to decide for this bill, for this circumstance, the difference that has been laid out before you. The fact is, this was a very highly negotiated bill. There are parts of it that I think different stakeholders struggled with on this bill. The main point about the business size we were trying to get to is there are businesses in California who know better, who have the resources to have done the research and ensure that there is access. There are businesses who are small enough that don't have those same resources, don't have that same education and knowledge. And it's incumbent on all of us to be able to provide that level of understanding to all businesses so that they do, in fact, come into compliance. The threshold that we're talking about here is an arbitrary one that was negotiated in this bill, and I certainly respect the concern about where that number is. But we're trying to make sure that we're setting a standard here and saying that a business that has the ability to come compliant needs to be able to do that. And businesses that don't have the same level of resources are given an opportunity to have a certified access specialist help them out. And it's only under those circumstances where that business has made that investment that there's any relief at all under this bill. I believe that we have set a reasonable balance in this bill, and again, I ask for your aye votes.
This time, the clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. The clerk will close the roll, tally the votes. Aye 63, noes 4. Measure passes. At this time, I'd like to acknowledge a former member of this body who is visiting with us today. I want to say hello to Assemblymember Mariko Yamada. With that, moving through the file item 82, we're going to pass and retain file item 83, SB 507. The clerk will read.
Senate Bill 507 by Senator Pavley, an act relating to sexually violent predators.
Mr. Cooley, you may present.
Colleagues, SB 507 clarifies that a district attorney has the same right to review state hospital records in a sexually violent predator case as a defense counsel. And the goal is to avoid releasing these sexually violent predators back into the community sort of on a technicality. Under current law, it's very clear that on an initial investigation, all parties have access to these records. In the course of this type of prosecution, occasionally there are updated mental health examinations of these predators. And as to those updated records, the law is not clear that the district attorney enjoys that same right that they do initially. So this will establish the standard that is uniform throughout the proceeding. This will avoid having people released because of a want of information in the hands of the district attorney. Good bill. I request your aye vote.
Seeing and hearing no further debate, the clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Aye 69, no 0. Measure passes. File item 84, SB 610. The clerk will read.
Senate Bill 610 by Senator Pan, an act relating to Medi-Cal.
Mr. Bonta, you're recognized.
Thank you, Mr. Speaker and members. I present SB 610, which requires the Department of Healthcare Services to finalize a new reimbursement rate and complete annual reconciliations for federally qualified health centers or rural health centers within specified timelines. Currently, there are no timelines that require DHCS to finalize reimbursement rates or annual reconciliations for FQHCs or RHCs. This has resulted in DHCS taking approximately 5 years to finalize a new rate and approximately 3 years to finalize reconciliation, which has resulted in the state owing nearly $50 million to the clinics. Although the timelines established by SB 610 may require funding for additional staff, this should be only a temporary position to help with the backlog of paperwork. SB 610 is not requiring the state to do anything new, but is simply holding the department accountable for the money they owe these clinics so that the clinics can continue to ensure access to quality care. The bill currently has bipartisan support and no opposition. I respectfully ask for an aye vote, members.
Seeing and hearing no further debate, the clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. The clerk will close the roll, tally the votes. Aye 68, no 0. Measure passes. Moving now to file item 85, Senate Bill 660. The clerk will read.
Senate Bill 660 by Senator Leno and others, an act relating to the Public Utilities Commission.
Mr. Rendon, you're recognized.
Mr. Speaker and members, I'm pleased to be working with Senators Leno and Wesso on SB 660, which reforms the California Public Utilities Commission's regulatory process that has resulted in serious failures to protect public safety and ratepayer interests. SB 660 is intended to address the flaws in CPUC process and operation and seeks to increase transparency in an effort to address the culture of coziness that may have compromised the public interest in the recent past. First, it limits the power of the Commission President, who currently holds a powerful influence on operation of the agency. The bill would require the full Commission, instead of just the President, to appoint the Chief Administrative Law Judge. Second, the bill creates new standards for considering whether a commissioner should be recused for bias or prejudice. Finally, SB 660 creates new rules for ex parte communications between CPUC regulators and the companies they regulate. I respectfully ask for aye vote.
Seeing and hearing no further debate, the clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 70, no 0. Measure passes. Moving to file item 86, SJR 9. The clerk will read.
Senate Joint Resolution 9 by Senator Stone and others relative to the Chronic Kidney Disease Improvement and Research and Treatment Act.
Mr. McCarty, are you prepared to introduce?
Thank you, Mr. Speaker. I'm pleased to present SJR 9 by Senator Jeff Stone, which urges Congress and the President to support H.R. 1130, the Chronic Kidney Disease Improvement and Research and Treatment Act. More than 20 million Americans in California have chronic kidney disease, and most cases are undiagnosed. This resolution raises awareness to this issue and asks Congress to act promptly and certainly urge our support. But first, I'd like to open the first roll-up for co-authors.
Seeing and hearing no further debate, Mr. McCarty has asked the first roll to be open for co-authors. The clerk will open the roll. Members, this is for co-authors. This is for co-authors. The clerk will close the roll. 66 total co-authors are added, and this is an SJR, so it requires a roll call vote. The clerk will again open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. The clerk will close the roll, tie the votes. Ayes 66, no 0. Measure passes. We're going to pass and retain file items 87 through 90. Moving now to file item 91, SB 387. The clerk will read.
Senate Bill 387 by Senator Jackson and Act relating to the State Bar.
Mr. Stone, you're recognized again.
Thank you, Mr. Speaker and members. This is the annual bar fees bill that comes to the legislature. It started in the Senate this year. Next year will start in the Assembly and the Judiciary Committee. With respect to the bar fees, it does keep them flat this year. They haven't been raised in a number of years, and that's typical of this bill. What is significant about this bill, and something that I think this House can take pride in, is through its oversight obligation, the Judiciary Committee has been working very closely with both the Senate Judiciary Committee and the Chief Justice to make some significant changes in this bill that will provide for enhanced transparency. The first is, through the next year, this bill provides for a comprehensive audit of the State Bar, something that has been lacking, as well as providing that the State Bar, as a state agency, will now be subject to the Bagley-Keene and the Public Records Act, both of which are the hallmarks for transparency in the state, something that I think we can all take great pride in, making sure that we are keeping all of our state agencies open and transparent, and that we are ensuring through this process that we're doing the appropriate oversight of the agencies, whether it's judicial or administrative, through our oversight authority as the legislature. So I respectfully request your aye vote. And again, I hope you take advantage of taking a look at this bill, what this represents for California. It's a great step forward. Thank you.
Seeing and hearing no further debate, the clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. The clerk will close the roll, tally the votes. Ayes 69, noes 0. Measure passes.